The last video deals with the final thing we need to cover for the course, and that's the issue of civil rights. And remember, we talked about the difference between liberties and rights, or negative or positive rights. Civil liberties are things that you should be able to do free of much or any government interference. They dominate the First Amendment, and then they relate somewhat to the remaining amendments in the Bill of Rights. The concept of civil rights is a standard that government must meet when it interacts with you. And then, as we identified in Roosevelt's speech, the transition in the 20th century to the things that you have a right to expect from government. If I recall, it was freedom, you're free from want. So somehow the government has to provide you the basic necessities of life. Um, and that argument can go on and on and on and on. It's going on now. Uh, and freedom from fear, I think, was the other one, which some would argue could potentially justify a police state. There haven't been a lot of amendments saying you must be provided things. Um, the 14th Amendment that we're going to talk about in great length here did provide sort of a set standard of how the government is supposed to interact. It doesn't necessarily say it has to provide you education, it has to provide you this, but if it chooses to, it has to do it in these ways. It has to follow these standards. Now, that being said, many of the state constitutions, for instance, Virginia's rewritten 1971 version, establishes the right to a free education. You have, you have a right to this. The government will provide this to you. And many state constitutions designate things that the government must do for you. It is not a major feature or a feature at all in the U.S. Constitution. Now, the first selection of slides here are just a hodgepodge of the history of what's occurred as we have tried to equalize or standardize the relationship between what the government is doing and the people out there based on their differing characteristics, their race, their gender, their ethnic origin, their sexual orientation, their age, their level of ability versus disability, how that has evolved over time. For most of American history, it was largely a political question in terms of did the politicians in a particular environment, in a particular region, in a particular state want to treat African Americans more equally to Caucasians than maybe other areas, or not, the reverse, treat them worse. It was basically left to the political process to make that decision, and you did have a patchwork. You had African Americans, former slaves, allowed to vote much sooner in some states in the North, etc. You had, for instance, when it comes to women and the right to vote, you had several Western states provide an opportunity for women to vote before it was standardized by the constitutional amendment. So it really was a patchwork, and generally not a very positive patchwork. There wasn't great efforts on the part of even states, even what we would call progressive states, to treat everybody the same, regardless of their religion, regardless of their race, regardless of their gender, and so and so. As we engage in the world, and I don't know if you learned about this in history, as we engaged in the world, and we're now seen, maybe in the case of Wilson, Woodrow Wilson on purpose, but maybe reluctantly seen as the quote unquote role model for Western society, particularly in contrast to fascism in the first half of the 20th century and then Soviet communism in the second half of the 20th century, then we sort of had to up our game if we are complaining about how governments are being run by the Nazis in Germany or the fascists in Italy or the communists in the Soviet Union. And yet we're not necessarily, what's the expression, practicing what we preach at home. Then it becomes a problem, and it elevated the attention. I think I don't know if you talked about this in U.S. history, but the night of the March on Selma, when the Alabama law enforcement just weighed in and attacked the marchers who were demanding the incredibly controversial right to access the ballot box. On that very night, one of the networks, I want to say it was ABC, was broadcasting for the first time on broadcast television a film called Judgment at Nuremberg, about the trials of the Nazis and how they treated people differently. And that broadcast got interrupted by live feeds from Selma, Alabama, of American police officials beating citizens in this country because of their race and their incredibly controversial desire to vote. It really created this paradox that America decided we were uncomfortable with, and it motivated Lyndon Johnson to push even stronger for the Voting Rights Act. He goes and gives his famous speech before Congress, urging that a Southerner with a Southern accent demanding a law to federally protect the right of citizens to vote. So it's a long, slow, checkered, intermediate evolution. And it's when we finally get to the 1960s, and you'll see several of the laws referenced there when it comes to employment, when it comes to education, when it comes to housing, voting, participation in the economy, when we're talking about the Civil Rights Act, then the federal government decides to finally step up and using that interpretation that, first of all, the demands on governments when it comes to schooling, etc. You don't have to interpret the Constitution. It says right there in the Fourth Amendment that, or 14th Amendment, excuse me, that nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of law. So when it came to requiring state governments, local governments to treat people equally, starting predominantly with race, you didn't have to make too hard a constitutional argument. Now, we've talked about this previously when it came to using the Commerce Clause in combination with the Necessary and Proper Clause to enforce that standard on private enterprise, and it became a little more controversial, you would think, but passed overwhelmingly in a post-Kennedy assassination era and was confirmed by the Supreme Court almost immediately in those two cases. The one with the Heart of Atlanta motel versus the U.S. government, and the U.S. government versus Ollie's barbecue pit. Katzenbach versus McClure. Katzenbach was either the Attorney General or the Assistant Attorney General of the United States. It moves beyond race, even as early as the 1960s, with legal requirements on how you should be treated based on your gender. And then we're going to talk about that in the second half of this video, that gender does not still today have the same constitutional protection that race, religion, and ethnic origin does. But the court has elevated its status above other ways we're differentiated, say our IQs or our size or our age. Most of the protections come through laws, whether it's you've got the Equal Pay Act on there, you got references to Title IX, and the aspects of educational opportunity if you take federal money. It expands into, well, the racial component. Initially it's African Americans, then it expands into a whole variety of other both race and ethnic origin issues. And then, of course, in the 21st century, we've had it extend into issues of sexual preference. Again, that is not constitutionally protected like race, religion, or ethnic origin. It has been legally elevated, some by law, some by states, and then, at least when it comes to same-sex marriage, by a decision ultimately in 2015, Obergefell versus Hodges, where the 14th Amendment, equal protection, is now applying to the granting of governmental marriage licenses, and with the issue of the participants in this marriage being same-sex. So we've gradually, over decade after decade after decade, with some constitutional amendment, number one, with some leadership from particular states or clusters of states doing things quote unquote better, fairer, more equitable, and sort of leading the way through eventual legislation and expanding those legislative areas to things on also side, I think it's on there, disabilities, the Americans with Disabilities Act, and various amendments regarding that in education acts. So that constitutionally, legally, we are making an attempt, not always successful, but to treat human beings as equitably as possible, regardless of their various demographic characteristics. Now, the second part of this video is going to be sort of parsing out, like everything we've talked about in these most recent units, where's the line drawn? It's not an absolute perfect equitable situation. Just because you're a living, breathing human being, you don't have a right to go to Harvard. They are allowed to set academic level standards and take the ones with the higher levels, not just anybody who's breathing, randomly pulled out of a hat. So intellectual capabilities would be one where differences are allowed, whether it's the public sector or the private sector, and not necessarily the Civil Rights Act or any other provisions apply to that. So we'll pause there, and then we'll get into sort of the court history in the slides that are not colored in dark blood red. I do want to pause. The College Board, and again with this very limited testing situation, does urge you to remember your letter from Birmingham jail by Martin Luther King Jr. And I think it just historically is a wonderful document, literarily, it's a wonderful document. Historically, it's a key moment in American history. But I think for government, it shows you, and he very makes clear the difference between the Supreme Court and the judicial branch and the other branches of government in terms of their real power. Very much, he read his Hamilton 78 that they won. I mean, the court was crystal clear in these decisions in the 1950s about not segregating, treating people differently based upon their race. And yet, not much was happening because it was just the say-so of 9 old farts on the Supreme Court. And it really was a claim to, people need to do more than that. It has to, the real power branches, the lawmaking branch, the law executing branch, has to come on record. And the proof is in the pudding. Not just talk the talk, but walk the walk. And that's part of that early 1960s push. And there are other factors. The protests that they staged, the consequences of the Kennedy assassination, the desire of Lyndon Johnson to one-up Kennedy on as many things as he possibly could, all of those turn rather tame, almost inaction by those two branches in the very early 1960s, 1960, 1961, 1962, into just a couple of years later, tremendous explosion of legislative ability. And letter from a Birmingham jail represents that, identifies, lays very stark that, words are nice, but action is what is necessary. And as Mr. Hamilton pointed out, it is the legislative branch, the power of the purse. It is the executive branch, the power of the sword, that can really make things happen. Judgment is wonderful. The judgment of the court that it's no longer acceptable to treat people this way when it comes to race or then gradually to other matters isn't enough. It was a start. It sort of threw down the marker, but that letter and his feelings and what happens after that represents the realization that it takes the major branches of government to make things happen and then stick with it. Okay, the slides leading into this video segment relate to the 14th Amendment, reminding you of what we talked about earlier with it. Specifically focusing on Section 1 of the 14th Amendment, which establishes citizenship. Although once you're declared a citizen, it's privileges and immunities that you get as a result of your citizenship. I want to remind you that persons can expect due process. Persons can expect equal protection of the law. Privileges and immunities only applies to citizens, which the court probably was having that in mind when it did not necessarily interpret privileges and immunities as extensively as the authors had intended it to incorporate the entire Bill of Rights. And maybe their intellectual judgment was, how could the Bill of Rights just apply to citizens only, while the other two things apply to everybody? Now, what that meant was they had to use the Due Process Clause or the Equal Protection Clause to require states in their interactions with individuals based on their differences to meet a certain standard. They had two ways of doing that. The very controversial one, probably when they are really stretching it in terms of throwing the law out, is the Due Process Clause, in particular something referred to as substantive due process. Now, it's ultimately in 1954 where they win the case in Brown versus the Board of Education. They get the court to look at the substance of separating people by race, not the procedure. They were winning cases, the NAACP were winning cases under a procedural due process because the Plessy versus Ferguson pledge of separate and but equal was clearly not being followed. But they were having to win that, for they were having to put evidence up in this school district or at this school or in this professional school. Clearly, the evidence shows the facilities, the opportunities, etc., are not equitable, and they were winning. Going back into the 30s, they were winning. But I mean, there are a lot of school districts in this country. There are a lot of schools in this country. There are a lot of programs, educational programs in this country, and it was going to take them 1,000 years if they were going to have to fight based on procedural due process. So they tapped into this issue, this notion of substantive due process that was first broached in a case that had to do about regulating the production of milk byproducts in the 1930s as part of the Agricultural Act. It's the Caroline Products case, and I can't remember who the other party in the case was. But one of the justices, in a footnote, not the main text of the opinion, talked about that the court also has a right to look at the impact of the law, the substance of the law. For lack of a more sophisticated way to say it, is in their eyes, is the law fair? Now, you can, right there, you should say, wait a minute. I mean, that's a briar patch to get stuck in, is to trying to sort out, one man's fair is somebody else's unfair. So it is a pretty controversial standard, but they argued that just saying you're different because of your race in this particular case, in the Brown case, and have to be treated differently because of that. The substance of that law, even if you could duplicate the educational facility and run it through a copier, and they were of absolutely equal quality, and that's why they went to Topeka and other school districts who were actually trying to follow through. They were trying to make sure the school buildings were just as good, the textbooks were just as good, the teachers were just as qualified. They were really trying to stick to the letter of separate but equal, because they didn't want to win the case on the textbooks were vastly inferior, the teaching was vastly inferior. They wanted to win on the principle of separating people by race. So I would urge you to read the court's opinion in Brown versus the Board of Education. It's laid out there, right there for you. Then they also, in the 1960s, they start getting into more aggressively using the equal protection of the law clause. And again, they get to be the judge of when is treating people equally based on a characteristic not permissible, when is it permissible. Over the course of 2 decades, they established the standard that is laid out in the slide that has the charts. I'm going to pause now, catch my breath, and I'm going to talk about that chart in particular. So, a government entity, state, local, or federal, because everything has been incorporated now, and the 14th Amendment specifies that equal protection applies to state governments, has chosen to treat people differently based on some characteristic. Okay? Or a private enterprise has chosen to treat people differently based on some characteristic and must meet a certain standard in doing so because they either fall under the one of the Education Acts, they take federal money for something, and therefore they agree to follow federal rules, or they fit under the Civil Rights Act because they're engaged in interstate commerce, which now means just about any private enterprise. So that they've chosen to treat people differently based on some characteristic. And an individual or a group of individuals who are in their mind treated less, better off, treated differently, complain and file a lawsuit. So the federal court will look at the characteristic and they will fit it into one of those three classifications. If it is one of the constitutional characteristics that are protected, and those are just race, religion, and ethnic origin, then you'll notice that there's a column called strict scrutiny. Up until the 1970s, if it wasn't one of those three, it couldn't be labeled one of those three, then it was treated all the same, any other characteristic, and that, keep in mind, included gender. In the 1970s, and as a consequence of the sun just came in, as a consequence of the women's rights movement and the move for the Equal Rights Amendment, which failed, the court decided to, because it's the court, they can do whatever they want, to carve out this new intermediate scrutiny. And the most significant characteristic, if it's in there, is your gender. A lesser known one is legitimacy, legally. Those who were born legitimately of married parents were treated differently from illegitimate children. That classification, it's not race, ethnic origin, or religion, but the court in the 1970s felt like it was antiquated enough that it probably needed to be it's more skeptically looked at by the court if you were treating legitimate children differently from illegitimate children. And then one would argue that maybe as a consequence of the same-sex marriage case Obergefell versus Hodges, that at least before the two conservative appointees of Donald Trump got on the court, that the court was moving gradually, unofficially, to gender preference, sexual identity, whatever you want to call it, perhaps moving that into that category. And then now the remaining things, okay, already out is race, religion, ethnic origin, that's strict scrutiny. Gender and legitimacy, and perhaps to some degree sexual preference, gets intermediate. Everything else is subjected to the rational basis test. And that is essentially what it sounds like. Does the distinction using this characteristic and creating this cutoff point for the characteristic, does it make rational sense? The thing to note here is that if it is that classification, the court tends to be deferential to the divider, whether it be the government or the private enterprise. They're going to give them the benefit of the doubt. Flip to the other side, when you go to strict scrutiny, the burden is massively on the government. What is the phrase there? Compelling government interest, I believe, is the phrase. I can't see the chart right now, but the government must demonstrate a compelling interest in using this characteristic to create this division. To put more colloquially, they better have a damn good reason. And we'll talk about how they've parsed that out over the course of the affirmative action history in this country. Intermediate scrutiny is sort of a jump ball, and some would argue it is sort of dependent upon the whims of the age. Will between Obergefell versus Hodges and hashtag Me Too, will the court be a little more demanding of treating people differently based on their sexual identity or their gender than they would have been 10 or 15 years ago? Maybe. What will it be 10 or 15 years from now? Which is, pause there, all you young ladies out there, which is why women in particular would really like to get the Equal Rights Amendment passed so there wouldn't be this whims of the time standard, at least for gender, if not sexual orientation, that it would be added to the strict scrutiny. So when there is a treating women differently by the government or by a private enterprise, it too is subjected to the compelling government interest strict scrutiny standard and not left to that amorphous middle ground. At least it's a higher standard than the rational basis test, which had existed for gender prior to the 1970s. An example of rational basis is the drinking age, or the age of maturity to marry or to get a driver's license. Um, you're 14 years old and say, I'm perfectly capable intellectually, physically of driving, and you take it to court. Its age, it will be subjected to the rational basis test, and the burden of proof will be on you, and in all likelihood, the state's going to win that argument. Um, so that's the impact of rational basis. There was another. I used to have a whole handout of different cases that came up. There was one where the airlines, which are heavily regulated by the Federal Aviation Administration, one airline had determined that if you were, I want to say 6'6", or I don't know if it was 6'6" and or 320 pounds or more, when you bought a regular ticket, the standard seating, you had to actually buy two. And bigger people complain, more expensive. Size, rational basis test, and the government slash airline industry talked about the safety of that particular individual, the safety of the aircraft, the safety of other passengers around them, and the court upheld size in this particular instance as legitimate, and this particular cutoff as legitimate for the government to do, and therefore not unconstitutional. Um, Now we could, we would in class we would have run through a series of these, and you get to see it, right? I mean, and obviously you start if you do focus on somebody is Jewish or somebody's black or somebody is family is native to Asia, um, alarm bells, red alert bells go off in the courts. Wait a minute, and they really put, generally speaking, the screws to the government um, in terms of legitimizing that different treatment. So, just to review, race, religion, ethnic origin, we're treating people differently in somehow, some way, primarily government, but also potentially private enterprise. It gets subjected to strict scrutiny, where the government has to have a compelling interest, a damn good reason, and we'll talk about momentarily, whatever they're doing has to be as minimal as possible in the narrowest possible fashion for the shortest possible time. The other extreme is non-controversial characteristics like age and size and perhaps your IQ is subjected to rational basis. The standard tends to favor the government's justification. And then, as a result of the 1970s, legitimacy, and in particular gender, and perhaps in the 21st century, sexual orientation, gets the sort of greater benefit of the doubt in favor of the group being discriminated against, but not quite the same standard as the three constitutionally protected characteristics. Now, in a weird quirk of history and fate, if you will, where the issue of treating people differently, particularly based on the sacred characteristics of race, ethnic origin, predominantly religion, probably less so. Didn't have to do with identifying somebody by a characteristic and treating them worse. It came up most frequently and has come up most frequently in identifying a group and treating them better. And that is referred to generically as affirmative action programs. They were the brainchild of the civil rights movement in the late 1960s, who said, okay, great, we've constitutionally and now legally and now perhaps practically forbade, if you will, the treatment of people differently based on race. And I think it was Martin Luther King talked about, having held back somebody for so long and saying, okay, everybody's equal now, go ahead and run the race of life or whatever, didn't seem quite fair. You had this group, African Americans, and then gradually it incorporated other racial minorities and then gender, who had been constitutionally, legally, practically, socially restricted for decades, if not centuries, from the opportunities to develop the kind of skills you needed to be able to effectively compete with white Christian males. So rather than just wait decades and centuries for that to balance out, there was a desire to accelerate opportunities for the select best of the best, if you will, of these characteristics, so they could sort of be the markers, the trailblazers, the role models for that racial group, for that gender, for women, to demonstrate to society, to business, to government that people of this particular characteristic, this race, this religion, this gender, women, could be good doctors and lawyers and whatever. So, programs were created in the 70s to admit the best, if you will, of these classifications on a separate scale, to give them the opportunity to be those trailblazers in that area. It doesn't get tested until the later 1970s, and the key case in this is Bakke versus the Board of Regents. Alan Bakke was, I don't know if he went undergraduate school he graduated from, but he wanted to go to med school at Cal Berkeley, a very good med school. The California system had established an affirmative action program, and I don't know what the actual numbers were. I'm going to use 100 just because it's easy. They used to create an admission score looking at test scores, references, etc. And then they would, from the highest one to the lowest one, put them on a scale, and they'd offer admission to the top 100. We'll use 100 for an easy number. And then, if somebody decided I want to go to Harvard instead of somebody else, they'd go to 101, 102, etc., until they'd filled their 100 slots. And invariably, year after year after year, the bulk of those slots were white Christian males. So the initial program was, I think, just for African Americans. I don't think Hispanic Americans were included. They took 15 of those slots and they put them in a separate category and said, if you in your application you've identified yourself as this group, and I think it was just African Americans at the time, you go on a separate scale, top score to bottom score, and the top 15 will be offered admission to Berkeley. The other group, white people, probably white women as well, for those that are in there, are in the other category, and they get the top 85 slots. Well, Alan Bakke didn't get in this system because, let's say, he was 92 of the, and they only went to 85 this time. And his case was, if it was the old system where everybody was just I would have been in the top 100. So this is discriminating against me because I'm white, sometimes referred to as reverse discrimination. So it went to the court, and it was sort of touch and go as how the court would rule in this case. And it was sort of to some degree, a split decision. The court upheld the principle of affirmative action, that you could create these programs to accelerate opportunities for identified groups. However, the method the University of California system used, oftentimes referred to as the quota system, was constitutionally not permissible. You had to create some system where everybody would still be on the same scale. So what they end up allowing for is something referred to as the plus factor, that the whatever the program is, Cal Med School, whatever, um, decides that if you were African American in the 1970s, early 1980s, because you had to overcome, in all likelihood, less educational opportunities, in all likelihood, perhaps your parents hadn't even gone to college. You were in, generally speaking, a poor school district that maybe have the resources. Um, and yet you overcame it to be a potential applicant to Cal Berkeley Medical School, then as a result, we'll add 5 points to your score. And that was judged to be constitutionally permissible. Now, the result of that is in one particular admissions year, that might result in 22 slots, 22 spots going to the identified minority or minorities. And then the other year, the plus factor might not be enough, you might only have 5. And it would so ebb and flow. It wouldn't have that sort of nice crystal clear, there'd always be 15. So those who were very much advocates for affirmative action weren't necessarily pleased with it. Those who didn't want to see any benefit given to anybody based on a characteristic weren't pleased with it, but it was sort of, and still is today, the constitutionally permissible means. Now, it's just because it's constitutional doesn't mean we do it. And very few schools still do this, mainly because it's been 40 years. The next case, Grove City College versus Bell. Bell was the Secretary of Education. Grove City College is a private school. Remember, the federal government likes to use its money as a way to worm itself into how private enterprise or even public schools or state governments do things. So the initial interpretation of the Title IX, I believe, was that if a school took any federal money for anything, then they had to follow the provisions of Title IX. So if a private school took some grant money in the science department, then the admissions department had to follow the standards, so on and so forth. And the court pulled back on how aggressive the law could be in terms of federal money. And it said that only the piece of the institution that takes the money gets to be subjected to the civil rights requirements attached to it. So if the science department is taking a grant, then the science department in hiring and promoting, etc., admitting, has to follow federal guidelines, but not necessarily the entire university. Now, the next case is very important because now we go to private business. And again, the federal government uses its money here as a way to manipulate private business. They establish programs to identify business enterprises that were disadvantaged because their ownership was a person of color, or in particular the construction industry, a woman. I believe the technical term was DBEs, disadvantaged business entities. So you got labeled a DBE. Okay, you're a female owning a steel manufacturing, fabricating plant. And then, okay, so you've got that identified. You're labeled with that. Separately, the federal government is helping do various building projects. So we'll say, and it's Colorado, and it had to do with building roads. A portion of it being paid for by federal money, and now it's government to government. So you got to follow the standards of the federal government if you want their money. You don't have to take it, but you're going to want the money. These were referred to as set-aside programs. So if you got this money, it meant that when you did all your subcontracting for the building of the road, the gravel, the asphalt, etc., the surveying, that X percent of those contracts, 10%, 20%, had to go to DBEs. So when you were doing the bids for, in this particular case, it had to do with guardrails, steel guardrails, manufacturing, producing, fabricating steel guardrails. They decided to give the bid to not Adirond, to another company that was identified as a business entity, even though their bid was higher. that Adirond had offered to do an appropriate set of guardrails for less money, which under the typical bidding process would mean you get the bid, you get the contract. But Adirond was a white guy, or at least not a DBE. So it went to the Supreme Court, and the case took years to percolate through the system. It went up and down a couple of different times. Ultimately, the point of this decision is DBEs are constitutional. Set-aside programs are constitutional. But in applying it, in the particulars of applying it, sort of similar to the Bakke decision, in the particulars of how you do that, you can only activate the DBE set-aside requirement if you can demonstrate there has been recent and localized discrimination in granting contracts for those type of programs. So if you could prove that within recent times, a decade or two, there's evidence that white businesses were given an advantage over non-white businesses in the granting of subcontracts for road construction, then you could mandate the program be applied. But if it's just to compensate for slavery or discrimination in the 1950s, that's not recent. Or if you can demonstrate, yes, there's serious discrimination in granting these contracts in the Southeast, but no evidence in Colorado, then you can apply it to the granting of contracts for the project in Colorado. You could do it for the Southeast. So this is the second part of that, what makes treating people different on race, religion, or ethnic origin, the strict scrutiny. That second part gets added in. Not only do you have to have a really good reason for doing this, i.e. recent discrimination, but your solution, the program you're trying to justify, has to be narrow. I believe the expression is narrowly tailored to address the issue. So identify, yes, if you can identify discrimination against non-white contractors in the mountain states, then this would have been completely permissible. But if you can't, it's not permissible. So again, narrowing the focus. Now, we go fast forward into your lifetime, although you're young, in 2003. We have two cases coming out of the University of Michigan. They are using plus factors still. One at the undergraduate, one at the law school level. And they're challenged. Is it appropriate to use these plus factors in this circumstance now in the 21st century? And so the University of Michigan has to justify both. Why are we doing plus factors for the undergraduate, just the general University of Michigan undergraduate population, and why are we doing it for the law school? Their justification, their compelling government interest for the undergraduate was we're trying to establish a diverse school community to better prepare everyone, particularly the white students, to deal in a world that is multicultural, multiracial, and that's our justification for giving a plus factor to these identified racial groups, to enhance the diversity of the college experience. The justification for the law school was we are providing very specific people, lawyers, to provide legal services to an increasingly diverse America. We need to encourage that pool of potential lawyers to include the many characteristics of the society they're serving. That we are attempting to diversify the profession so that it's more effective in identifying with, empathizing with the clientele that they need to serve in a 21st century America. This again, split decision. The court does not accept the argument, the compelling government interest for the undergraduate, that just having diverse campus is an important part of the overall package of your University of Michigan experience. So that's ruled unconstitutional. But the law school justification was accepted. Okay. Now we get deeper into your lifetime, somewhat more recent, and this has been the trend to use something other than race as a way to still accomplish affirmative action. And it came out of the University of Texas. Now, some states have gone to not even bothering to ask about your race. What they want to know is, and will give you plus points, is for if you are coming from a disadvantaged socioeconomic status point of view. Your parents were low income, your school district was, its per pupil expenses were quite low, its percent of students on free and reduced, in other words, poor students, are very high. Um, your family, you're the first generation to even attempt to go to college. That's what they want to know. And based upon the answers to that, they classify you as a deserving SES candidate for plus factor. And they never ask you your race. They don't care. They're looking to compensate for the fact that you've overcome these challenges and are still in the ballpark of getting into our university. And if you happen to be black, you happen to be Hispanic, you happen to be a bloody Vulcan, it doesn't matter. Those have been tested and held constitutional. Texas, in this case, did something different. And it's really weird because they decided to diversify their University of Texas system by counting on the de facto segregation of their high schools. Um, they had predominantly Hispanic population high schools, predominantly African American high schools, etc. So what they did is they had, and I don't think it's top 10 anymore, I think it's gotten narrower than that. They offer automatic admissions to the system. It doesn't necessarily mean you're going to go to Austin, but to the UT system, to the top 10% of every high school in Texas. They offer it, doesn't mean you have to go. And as I said, it doesn't necessarily mean you're going to go to the University of Texas at Austin, flagship university. So they're counting on the fact that there are predominantly African American high schools that have been segregated by that's where people live. So that 10% is going to be African American and Hispanic, etc. Fisher was a kind of plain, in fact, she's in the lower right hand corner, just a white girl. Decent, but went to a predominantly white school, did not finish in the top 10%, but argued her package of grades, test scores, etc., put her ahead of other people that were coming from the top 10% in a not white, or maybe even a white but less affluent school. She challenged it. It went back and forth for years. Finally, the court ruled in favor of Texas. Um, I just think it's bizarre. Your university system is counting on the segregation of your high schools to help it become more diversified. But is their top 10% is constitutionally allowable? Um, Texas is becoming purplish in some ways, so I don't know if politically they'll pull back on that. Um, and sort of that's where we are. Um, you'll also notice the vote was 4-3, only 7 participated. Scalia was dead, had not been replaced, and one of the justices, I want to say it was Kagan, had been part of preparing the Obama administration's amicus brief on the case. So she recused herself because she had a history of being on one side in the case. So that's why the vote was only 4-3. Now we do have Gorsuch and we have Kavanaugh on the court now, the Trump appointees. At some point, somebody is going to challenge whether it's the set-aside program, the 10% rule, the plus factor for SES or for a particular race. And it's going to go back to the court, and now you have Gorsuch and Kavanaugh on the court. Could they get to the point where, I mean, I don't know how they could say SES is unconstitutional. I have a hard time with that one, but could they say you can't use plus factors anymore? You can't use anything. You got to take race off the application entirely, ethnic origin, etc. We'll see. Those are in cases yet to come. Okay, the final separate topic of civil rights and when to treat people equally or not has to do with sexual, gender, identity, preference, etc. Up until 2015, for about a little over a decade, it had been primarily wrapped up with the argument over the granting of marriage license to same-sex couples. So we go back to the early 1990s. Um, the status was all 50 states gave marriage licenses to non-related, not blood-related male and female, a male, a female. There was a big fight in Utah over a century ago about polygamy. And I want to say Hawaii went first, um, but using the state court system, advocates for same-sex marriage using various bills of rights in the state, and remember this is the state granting the license, began to win court cases in Hawaii, in Massachusetts, where the state Supreme Court said in order for the states to fulfill their constitutional obligations under their state constitution, if they're going to give marriage licenses to heterosexual couples, they have to give them to homosexual couples. Vermont was a state that experimented with a halfway thing called a civil union, that it wouldn't necessarily be a full-fledged marriage, but legally, at least in the eyes of officials in Vermont, all the various characteristics legally of a marriage would apply to a civil union. That's great. And that's fine if the only people who accessed this were residents of those states and they lived out the rest of their lives in those states. But we go from state to state. You can go to Vermont, you can go to Massachusetts, you can be a homosexual couple from those states with a license and go live somewhere else. I mean, one of the few privileges and immunities that you have under that 14th Amendment interpretation, according to the court, is the right to move from state to state without interference by states. Which is why, if you recall, it was a little bit, there was a lot of tension when I think it was Rhode Island was putting state police at their border and paying particular note and stopping people coming from New York early in this pandemic crisis. Now, some states have said, you're coming from these areas, you have to isolate. We hope that you isolate for 14 days. That's probably less a violation of privileges and immunities. So, people from Hawaii, people from Massachusetts with these same-sex marriage licenses, people from Vermont with the civil union would then go and live in another state and expect to, under the full faith and credit clause, to be treated as legally married couples. I usually in class ask how many of your parents were married in another state, and then I follow up that question immediately with, did they have to get remarried when they moved to Virginia? Well, of course not. The license was valid in Virginia, part of that full faith and credit. So this created a controversy in the mid-1990s, and Clinton was fighting battles on many fronts, trying to prove that, one, I am not the classic far left wing Democrat, so I can be different from that. Two, I have to recognize that I'm representing, a southern state. And three, trying to work out ways to get along with a Republican Congress. So he agreed to sign off on a law called the Defense of Marriage Act. And the Defense of Marriage Act did two things. For purposes of engaging with the federal government, your taxes, etc., they said that only marriage licenses between heterosexual couples would be valid as proof of marriage. The big deal is obviously with taxes, but it could be with various other benefits or other programs accessing the federal government. So the law defined marriage in terms of the federal government as a marriage between a man and a woman. It also told the 40 some odd states who did not have same-sex marriages, if you choose to, you do not have to recognize the marriage licenses of people coming from Vermont, Hawaii, and gradually other states started joining the parade. So DOMA is passed, the Defense of Marriage Act, and we are sort of left for the end of the 1990s and the early 2000s, gradually state by state, whether by legislative action, although it was rare, but by judicial action using their state constitutions, more and more states were adjusting and providing marriage licenses to homosexual couples. The court gets a case, and do I have the name of it up there? Oh, I didn't put it up here, and I can't remember it off the top of my head. It was a case out of New York, had to do with survivors' benefits, and it's survivors' benefits under Social Security federal law. And in that case, the court threw out the right of the federal government to define marriage at all. They said licensing marriages is a state function under the Ninth Amendment, the police power. So if they have a license from Hawaii and they're a homosexual couple, the federal government has to treat them as married, period. But it did not address the aspect of DOMA that told states they didn't have to accept marriage licenses from other states. Now, where this was becoming increasingly controversial and was probably motivating the court to maybe do something about that was child custody disputes between same-sex couples who had been married, adopted, or through fertilization obtained a child, moved to a different state where they technically weren't treated, or moved to different states and there was disputes over custody of the children. It became very messy, and in the right around 2010-ish, as we moved into the second decade, there was a feeling like the court was going to have to do something about this, about that second part of DOMA. In particular, Justice Anthony Kennedy was very suspicious about the implication of this and becoming increasingly reluctant to allow it to be a domino effect state to state. And that leads us to 2015 and the Obergefell decision, where finally he becomes the fifth justice, the swing vote that says enough is enough. I have now decided to, in subjecting this to whatever scrutiny you want to call it, decide that accessing marriage is a fundamental right that even homosexual couples should have an opportunity to do under the 14th Amendment. And at that point, we're done. Now states, in order to, now that being said, states could choose to get out of the marriage license business entirely. Now they're not going to do that, but they could. If they choose to stay issuing marriage licenses, they can now no longer treat a same-sex couple differently than a heterosexual couple. I've given you the link to that decision. Justice Roberts, in particular, was frustrated with Kennedy's logic in this, but you see in the mind of Anthony Kennedy that changing expectation of what rights are and who qualifies, and in this particular case, the issue of gender preference, etc. And that leads us now to the opening of the third decade of the 21st century and some of the questions I put to you there in terms of all the various letters, the LGBTQ, etc. And how are we going to accommodate that? We've got pushback in places like North Carolina. From the other extreme, we've got more in, say, the state of California, more recognizing of these gender preference differences, etc. And we would have had, if we'd had time, a discussion in class about particularly bathrooms. And if somebody identifies as a gender different from their birth certificate, what bathroom do they get to access, and other various ramifications of that. And in particular, we would have had a discussion of what would you like to leave to Prince William County Schools as an idea for how we should proceed. And it'd be fascinating to know the various dormitory bathroom circumstances in whatever universities you're going to. Those liberal bastions of far left equality. So that finishes off this video and finishes off our video reviews.